I'm pleased to start with our first speaker, Professor Jason Anthony Robison. He's an assistant professor at the University of Wyoming, and he joined our faculty, thank goodness, at the UW College of Law during the 2014-2015 academic year. He had served for a year as a visiting professor with us. Professor Robison earned his Bachelor of Science degree in Environmental Studies at the University of Utah, a JD at the University of Oregon School of Law. We have two ducks here, I understand. They keep telling me they're both have gone to Oregon, and if you don't know, they're the Ducks, and they're celebrating that. So a JD at the University of Oregon School of Law, a Master of Laws, and also quite unusual, I think, and I've been around lawyers for a long time, a Doctor of Juridical Science and his Master's both from Harvard Law School. While completing his JD, Professor Robison worked for the Special Litigation Unit of the Oregon Department of Justice, as well as for the Motions Department and Office of Appellate Legal Counsel of the Oregon Court of Appeals. He also clerked for Oregon Supreme Court, working primarily for former Chief Justice Paul Demunitz. He also did a number of fellowships at Harvard Law, and also in the Colorado River Governance Initiative at the University of Colorado School of Law. You can see he is definitely an expert in what he's going to tell us about. He's also the author, of course, of several publications. So today, Jason will share his expertise with us in a presentation entitled Montana versus Wyoming, the Yellowstone River Compact in the United States Supreme Court. Please welcome Professor Jason Robison.
Thank you very much for the invitation to speak. It's my pleasure to participate in Saturday University. I'm grateful for the hospitality both this morning and yesterday night from Western Wyoming Community College. If interstate water compacts are analogous to, quote, domestic treaties between states, which is what the father of interstate water compacts, Coloradan Delph Carpenter, thought they indeed were, then it's fair to say that Wyoming has been involved in what might be characterized as a major treaty conflict with its northern neighbor, Montana, in the U.S. Supreme Court going on about a decade now. A great deal of money, time, and thought has been invested into this dispute, both by the states themselves as well as by the federal judiciary. And the basic goal of my presentation is to contextualize and chronicle the litigation for you. To do so, I'll make my way through three broad subjects, looking first at the U.S. Constitution and its Compact Clause, then moving to how Wyoming has utilized this clause to form a host of interstate water compacts with its neighbors over the past century, and then finally drilling down to the subject at hand, Montana versus Wyoming, the one compact dispute in which Wyoming is currently engaged before the U.S. Supreme Court. At the end of the day, I hope you'll come away from the presentation with an understanding of the litigation's history and its current status, its relationship to Wyoming's other interstate water compacts, and ultimately the legal bedrock of the entire subject matter, and that is the U.S. Constitution. That bedrock is where we will start. And I'll pose what I hope will be an interesting question. How many of you have read the U.S. Constitution? Not read what others say it says, but have read the document itself. Show of hands? Okay. Better than in some crowds. I asked law students that. You'd be surprised what first-year JD candidates may have to say. It's the supreme law of the land. All federal and state laws must bow before it. On one hand, the Constitution mediates the relationship between individual citizens and government, addressing subjects like equal protection, due process, and free speech. On the other hand, the Constitution structures the relationship between different branches of the federal government, addresses separation of powers, as well as addresses the relative spheres of authority of the federal and state governments. That is, the concept of federalism. The Compact Clause exemplifies the federalism function of the U.S. Constitution. And I'll ask again, anyone happen to be familiar with the Compact Clause of the U.S. Constitution coming into Saturday University today? One taker. Be curious why that might be, but maybe we can chat after the presentation. It's not, I would say, it's a salient part of the Constitution, but maybe not one given as much airtime as, say, the Equal Protection Clause or the Due Process Clause or free speech, or First Amendment for that matter. The Compact Clause appears in Article 1, Section 10, Paragraph 3 of our Constitution. Its text is stated in the inverse as a prohibition. No state shall, without the consent of Congress, enter into any agreement or compact with another state. My translation, states may enter into interstate compacts subject to congressional consent. The clause has a deep, interesting history that goes back 400 years, but I'll only note one aspect of it. Anyone want to guess where the clause came from immediately prior to the U.S. Constitution? Basic U.S. history, basic political history. What preceded the Constitution? That's right. So, the Compact Clause's immediate predecessor was this provision. Article 6 of the Articles of Confederation. No two or more states shall enter into any treaty, confederation, or alliance, whatever between them, without the consent of the United States in Congress assembled, ... The text reflected the colonial past along the eastern seaboard under British rule, and again, it basically mirrors the Compact Clause as it was drafted into the U.S. Constitution. As a practical matter, why include these provisions? What types of disputes would the framers of the Constitution and the authors of the Articles of Confederation have had in mind? What do you think? What's your common sense tell you? Why would you empower states to enter into compacts? Take a shot.
Waterways going between two states, rivers.
Close. Certainly if those waterways were land boundaries, and in the 20th century and 21st century, more in the allocational sphere as well. So the earliest and most continuous use of the Compact Clause after and even prior to the framing of the Constitution was to resolve interstate disputes over land boundaries. States engaged in disputes of this type were capable, if they saw fit, of resorting to the U.S. Supreme Court and having the court exercise its original jurisdiction to address these types of disputes. I'll circle back to that theme of original jurisdiction later. But in lieu of relying on the U.S. Supreme Court, states frequently worked together to arrive at a compromise regarding the precise boundary of a shared territorial boundary, shared territorial line. And the states would then go to Congress rather than to the U.S. Supreme Court with a compact embodying the compromise they had reached on their own, and Congress's sanction of the compact ultimately would bring the compromise into effect. The land boundary compact formed in 1820 here between Tennessee and Kentucky provides just one example of this historical use of the Compact Clause. But against this backdrop, 2 decades into the 20th century, the Compact Clause took on new relevance. One might say it took on a new life. And these developments largely were due to this historic figure, Delph Carpenter. Carpenter's biographer was a member of the history faculty at Colorado State University for many years, Daniel Tyler. He relied on Carpenter's nickname for entitling his book, The Silver Fox of the Rockies. How's that for a nickname, right? Carpenter's background, in a nutshell, interesting character. A native of Greeley, Colorado, descendant of Union colony settlers in that area, i.e. agricultural background. Graduate of the University of Denver School of Law, right around the turn of the 20th century, 1899. Member of the Colorado Bar, one-time senator, state senator for Greeley from 1909 to 1913, but most importantly, for purposes of this presentation, lead counsel for the state of Colorado in a lawsuit in the Supreme Court over none other than the river right down the road from my house, the Laramie River. And that lawsuit was Wyoming versus Colorado. It was a trans-basin water diversion project, the Laramie-Poudre Tunnel, that precipitated Wyoming versus Colorado in the U.S. Supreme Court in the early 20th century. The tunnel had been conceived of as far back as 1897 but ultimately was constructed between 1909 and 1911 to bring flows from the Laramie River headwaters there in the Medicine Bow to agricultural areas in the vicinity of Fort Collins and Greeley. Again, it was a trans-basin water diversion project. The problem was senior water rights holders relied on the Laramie River's flows on the Wyoming side of the state line. They were concerned, understandably, about the tunnel's potential impact on the future availability of these flows that they had grown reliant on. And that's basically what brought the two states into the U.S. Supreme Court. Now, Delph Carpenter was appointed, that's not Delph Carpenter, we'll come back to him though. Delph Carpenter was appointed Colorado's lead counsel in 1911. 11 years later, in 1922, after 3 rounds of oral arguments before the U.S. Supreme Court, the court finally reached its decision regarding the relative rights of Wyoming and Colorado to water from the Laramie River. And the author of the court's opinion, pictured here, Justice Willis Van Devanter. Anyone familiar with Justice Willis Van Devanter? What's arguably his biggest claim to fame? Somebody get this question right. I will buy you a beer. If you're of age. Come on, Van Devanter. Justice Van Devanter is the only Wyomingite up to this point in U.S. history to serve as a U.S. Supreme Court justice. One. And that is him. Justice Van Devanter, writing for the full court, pictured here, announced a rule for allocating water from interstate rivers that would change Western water law forever. It would bring the Compact Clause of the U.S. Constitution into play in this realm of interstate water relations. The rule was this: where two states engaged in a dispute over their shares of water from an interstate river, both adhered internally to the doctrine of prior appropriation. The core tenet of that doctrine for allocating water, first in time, first in right, would apply on an interstate basis. First in time, first in right, temporal priority would guide the Supreme Court's determination of how much water states would be entitled to use from interstate rivers. Now, this interstate application of prior appropriation would work in Wyoming's favor in Wyoming versus Colorado, but it would not do so in what was a much more important context, and that is the Colorado River Basin, in which Rock Springs is located, and we are here today. Efforts by Delph Carpenter and others contemporaneous with the Wyoming versus Colorado lawsuit aimed to figure out the shares of the 7 states with territory in the Colorado River Basin. How much water would each state, or should each state, be entitled to use from this massive system, the mother of all Western river systems, in my view? Where do you think most of the oldest water rights exist in the Colorado River Basin? Any takers on that one? Precisely, in the lower basin, in Southern California, particularly southeastern California. In this area, think of the Imperial Irrigation District as probably the classic example. So the rub was that if the principle of first in time, first in right were applied on an interstate basis for the Colorado River system, it would have profound implications for the ability of upper basin states like Wyoming to use, at least consumptively use, water from the Colorado River system. Delph Carpenter and others recognized this concern and related off-putting aspects of arguing interstate water fights before the U.S. Supreme Court over the course of the Wyoming versus Colorado lawsuit. Impaneled as the Colorado River Commission, pictured here, Carpenter's on the far left. Herbert Hoover, then Secretary of Commerce, subsequently President of the United States, was the chair of this commission. They ultimately came together in early 1922 to try to utilize the Compact Clause in what was then a novel way, and that was to form the first interstate water compact in U.S. history. The general theory was that the compact would serve again as a, quote, domestic treaty, analogous to treaties formed by nation states over international rivers. Think the Danube River, for example. Suffice it to say, the court's decision in Wyoming versus Colorado, again, applying the first in time, first in right principle on an interstate basis, spurred this effort. Roughly 6 months later, on November 24th, 1922, the Colorado River Compact was signed at Bishop's Lodge just outside Santa Fe, New Mexico. Western water law had entered a new era. Bringing all this back to the Compact Clause, Western states learned throughout this process, Wyoming versus Colorado and the Colorado River Compact negotiations, that as an alternative to bringing an interstate water suit in the U.S. Supreme Court, like Wyoming versus Colorado, they instead could rely on the clause as an alternative to accomplish what would arguably be a better result. And this lesson was especially important for the state of Wyoming. As JJ and Craig, my co-speakers here this morning, will discuss in greater detail, and as all of us know from living in and traveling around the Rocky Mountain region, Wyoming is a headwater state. More precisely, it is a headwater state that has a semi-arid climate and that has no less than 6 neighbors also with semi-arid climates. So, from a legal perspective, this information is relevant for the reason captured by this map. Over the course of the 20th century, beginning with the Colorado River Compact in 1922, Wyoming gradually ironed out its interstate water relations with its 6 semi-arid neighbors for most, but not all of its interstate water bodies. There are 3 interstate basins in white that haven't been addressed: South Platte River Basin, Cheyenne River Basin, Little Missouri River Basin, but most importantly, those that are colored have. To be clear, 2 of the colored interstate basins, the Laramie and North Platte River Basins, the former being a sub-basin of the latter, to be precise, are subject to Supreme Court decrees. That is, interstate water compacts were not formed for these basins, but rather the Supreme Court was called upon to determine the state's shares of water through a legal doctrine that I don't have time to get into called equitable apportionment. In most instances, though, interstate water compacts have been the instrument of choice. Wyoming is a party to 7 interstate water compacts in total, second only to Colorado in this regard. Any guesses on Colorado's number of interstate water compacts? Want to take a stab? We're at 7. We're second. 9. That's right. 9 interstate water compacts in Colorado. Again, another headwater state. As you can see, Wyoming's compacts capture roughly 50 years plus of Western legal history, 1922 to 1978, with the compact that will be the focus of the remainder of the presentation this morning, coming into existence right in the middle of this time frame, and that is the Yellowstone River Compact here. Formed in 1950, what we know now as the Yellowstone River Compact is actually the 4th interstate water compact attempted by the 3 states with territory that fall within the Yellowstone River Basin: Montana, North Dakota, and Wyoming. The earliest attempts to create an interstate water compact for this basin date to the early 1930s, 1932 to be precise. Like its counterparts in the table just shown a second ago, the Yellowstone River Compact basically can be understood as aiming to accomplish 2 things. Number 1, to create an interstate water allocation scheme, and number 2, to establish an entity responsible for administering that interstate allocation scheme, the Yellowstone River Compact Commission. Here is the place in the West to which this compact, the Yellowstone River Compact, applies: the Yellowstone River Basin. More specifically, the interstate allocation scheme established by the compact, its apportionment, that's the legal term for it, its apportionment, applies to the, quote, Yellowstone River System, which is defined in Article 2 of the compact as, quote, the Yellowstone River and all of its tributaries, including springs and swamps, from their sources to the mouth of the Yellowstone River near Beaufort, North Dakota, this area where it connects with the Missouri, except those portions thereof which are within or contribute to the flow of the streams within the Yellowstone National Park. National Park is exempted from the apportionment. How exactly is the water from this system to be allocated among the states? Article 5 of the compact addresses this subject. It lays out an apportionment with 3 tiers. And it's important that you understand the nature of these tiers, the specific text here, in order to understand Montana versus Wyoming. This text represents the first tier, Article 5A. It essentially grandfathers into the allocation scheme any water rights in the Yellowstone River system that existed when the compact was formed. It grandfathers pre-1950 water rights. In turn, the next section of the compact, Article 5B, lays out the second and third tiers of the interstate allocation scheme. It applies to unused or unappropriated water in the Yellowstone River's interstate tributaries when the compact was formed. Clark's Fork, Bighorn River, Powder River, and Tongue River. Some of this water this is the second tier, some of this water is required to provide, quote, supplemental water supplies for the water rights mentioned in Article 5A that predated the compact. Again, pre-1950 water rights, supplemental water for pre-1950 water rights. That's the second tier as laid out in Article 5B. Whatever amount is left over, though, is allocated to Montana and Wyoming on a percentage basis. For example, remaining flows in the Tongue River are parsed out 40% to Wyoming, 60% to Montana. There are many other details associated with the legal architecture of the compact's apportionment scheme. But these two provisions, Article 5A, especially Article 5B to a lesser extent, really capture the gist. Now, of course, creating an apportionment without any sort of oversight or administrative plan would be foolish, and that's where this entity comes in, the Yellowstone River Compact Commission. In Article 3 of the compact, the commission is established and mapped out. Specifically, Article 3A creates the commission to administer the compact's provisions as between Montana and Wyoming and specifies how exactly the commission will be made up. It consists of 3 officials, one Montana representative and one Wyoming representative, both selected by the respective governors, and one federal representative selected by the director of the U.S. Geological Survey if requested by the states. So the federal representative serves as the chair, but generally does not have a vote, generally lacks voting power. This provision contains the lone exception to that dearth of voting power. If the state representatives disagree on a matter pertaining to the proper administration of the compact, the federal representative is authorized to cast a tiebreaker vote. Lastly, I expect some might be wondering, what exactly is the Yellowstone River Compact Commission authorized to do? I can provide a snapshot of that. These two provisions address the subject. First, Article 3C gives the Commission jurisdiction over, quote, the collection, correlation, and presentation of factual data, the maintenance of records having a bearing upon the administration of the compact, and recommendations to the states upon matters connected with the administration of the compact. You see that recurring emphasis on compact administration. That is the takeaway. In turn, Article 3E authorizes the Commission, quote, to formulate rules and regulations and to perform any act which they may find necessary to carry out the provisions of the compact and to amend such rules and regulation. So, that is a snapshot of the Compact Clause of the U.S. Constitution and the Yellowstone River Compact as an example of one of 7 cases in which Wyoming has exercised its state sovereign prerogative to form an interstate water compact with its neighbors. But the formation of a compact, of course, does not mean that everybody just lives happily ever after. And that brings us back to the U.S. Constitution and to Montana versus Wyoming. The U.S. Supreme Court has original jurisdiction over interstate water fights under this provision of the Constitution. Article 3, Section 2. I won't read through the text, but the highlighted text identifies the jurisdictional scope, the original jurisdictional scope of the U.S. Supreme Court. These fights, on one hand, may be equitable apportionment fights, like that which surrounded the Laramie River, Wyoming versus Colorado. Or they may be fights over the interpretation of interstate water compacts, and that's what we're dealing with in Montana versus Wyoming. Montana versus Wyoming actually involves issues that go back decades regarding how the Yellowstone River Compact should be interpreted and how it should be administered, particularly Article 5 that we went through just a moment ago. Drought and low flows in 2004 and 2006 brought these long-standing issues finally to a head. Montana made compact calls both of these years, requesting Wyoming to cut back certain tributary water uses in order for Montana to receive flows to which it considered itself entitled under Article 5 of the Yellowstone River Compact. But Wyoming disagreed that Montana indeed was entitled to these flows, and so the two states ended up in the U.S. Supreme Court in 2007. The litigation has spanned almost a decade now, almost 10 years flush next year, and these are the major milestones that I'll focus on to run through it. This is the document that put the judicial proceeding into motion. It's Montana's complaint filed before the U.S. Supreme Court in January 2007. Although the compact's apportionment scheme in Article 5, again, applies to the entire Yellowstone River system, Montana's complaint was narrower in focus. Montana alleged that Wyoming had violated Article 5 of the Yellowstone River Compact in relation to two interstate tributaries, the Tongue and the Powder Rivers, just these two. I'll talk about the specific years associated with Montana's allegations that Wyoming had violated the compact in just a moment. It's actually important, but we'll hold off on that for now. The complaint laid out, again, filed in 2007, January 2007, the complaint laid out in a lot of detail, 5 different paragraphs, exactly how Wyoming allegedly had violated the compact according to Montana. This paragraph, though, paragraph 8 of the complaint, really captures the essence of the lawsuit. Wyoming basically had not been cutting back post-1950 water rights as required, according to Montana, to ensure Montana's pre-1950 water rights were being satisfied. That is the crux. Montana alleges it has pre-1950 water rights that are protected under Article 5 of the compact, and that Wyoming has post-1950 water rights holders that have been satisfied to the detriment or the derogation of Montana's pre-1950 water rights holders. That's the essence of the litigation. It would fall to this gentleman, Stanford Law School water law professor Barton, he goes by Buzz Thompson, to address this issue. The Supreme Court appointed Professor Thompson as special master in the proceeding in 2008, and he remains in this position today. Apparently, no good deed goes unpunished. So, the first major document released by the special master in the litigation was this first interim report. It addressed various motions that Montana, Wyoming, other parties, the Northern Cheyenne Tribe, Anadarko Petroleum, had filed during the 2-year period since the special master had been appointed. So 2 years of court filings. Among other things, the special master fielded these motions and made 3 rulings, actually 4 rulings, that I would argue are the most critical aspects of the first interim report. First, Article 5A of the compact, according to the special master, indeed protected pre-1950 water rights in Montana from diversions and withdrawals for post-1950 water rights in Wyoming. Second, at the same time, where Montana could remedy shortages to its pre-1950 water rights through some sort of intrastate means without having to make a compact call, the special master said Montana was obligated to do so under Article 5A of the Yellowstone River Compact. Third, Article 5A, according to the special master, applies to tributary groundwater. Groundwater pumping by post-1950 water rights holders in Wyoming that might injure pre-1950 water rights holders whose rights attach to surface flows in Montana. The special master left open the circumstances when groundwater pumpers in Wyoming would have to be curtailed. Didn't go there in the first interim report, but rather tabled that issue for the second report. And finally, the most visible ruling, and if there's any that you remember of this bunch, was this one. According to the special master, Article 5A does not prohibit Wyoming from allowing irrigators with pre-1950 water rights to divert the same amount of water historically diverted and to use this water on the same land historically irrigated while switching to more efficient irrigation methods. For example, switching from flood irrigation to a sprinkler system. That was not prohibited according to the special master. Get this, even if the switch caused less water to return to the source from which it is diverted. That is, even if the transition or switch to more efficient irrigation methods caused return flows to drop and therefore caused the consumptive use of a given water user to increase. That was allowed according to the special master. Why was this particular efficiency ruling important? Well, it was certainly important to the irrigators themselves, but this is another reason. The next year, this ruling ended up before the U.S. Supreme Court. Special master's rulings in interstate water compact litigation can be taken exception to and appealed from in the same manner as state trial court rulings, like Wyoming District Court rulings, can be appealed to the Wyoming Supreme Court. Special master's rulings can go up to the U.S. Supreme Court by appeal in the same way. And that's exactly what happened in this case. Montana took exception to 2 of the special master's rulings, and the U.S. Supreme Court ultimately agreed to address one of them. Again, the efficiency ruling. The justices split 7-1 on whether the special master had gotten the efficiency ruling right. Justice Scalia, hopefully all of you know, recently deceased, said no. The special master had gotten that question wrong. Justice Kagan, Elena Kagan, for reasons unbeknownst to me, took no part in the decision. She recused herself from the decision. The remaining 7 justices, however, joined an opinion written by Justice Clarence Thomas, pictured here, affirming the special master. Here's the relevant excerpt of the majority opinion. Suffice it to say, it said the same thing as the special master had said a year prior. Wyoming irrigators with pre-1950 water rights could take the same flows they historically had diverted and apply these flows on the same land that they historically had irrigated, even if they begin using more efficient irrigation methods that cause return flows to drop in a way that reduces water availability to pre-1950 water rights holders in Montana, even if, in other words, it causes state line flows to drop as a result of the efficient irrigation. Mind you, it was 4 years into the proceeding at this point when the court issued this initial decision, and a trial hadn't even taken place at this point after 4 years. That would come to pass, pardon, that was the slide that I should have shown a second ago. And here's the courthouse in Billings, Montana, where the trial did come to pass in fall of 2013 after additional legal wrangling. Leading up to trial, Montana and Wyoming agreed to split the proceeding into 2 phases, a liability phase and a remedy phase. And further, Montana withdrew its claims that Wyoming allegedly had violated Article 5 of the compact with respect to the Powder River. So only the claims pertaining to the Tongue River remained. In a nutshell, the trial court looked solely at Wyoming's potential liability for violating the Yellowstone River Compact along the Tongue River for particular years specified by the special master. This second report, issued in December 2014, is what came out of the trial. It included a host of rulings, but I'll summarize them very briefly. First, according to the special master, Montana is obligated under Article 5A of the compact to provide notice to Wyoming if there is insufficient water to satisfy Montana's pre-1950 water rights. I think that's pretty commonsensical. According to the special master, however, Montana only did so in 3 years that were at issue, 1981, 2004, and 2006. But only the latter 2 years were relevant, according to the special master, because in 1981, Montana had not been injured in any way after providing the notice. Second, the special master looked at whether Montana's pre-1950 water rights had been shorted after Montana had provided notice in 2004 and 2006. And the special master said, yes, state line flows were shorted in 2004 and 2006. Third ruling, how much water had Wyoming allowed its post-1950 water rights holders to divert and store in 2004 and 2006 after Montana had provided notice? And further, what was the impact of this post-1950 water rights use in Wyoming on water rights users, pre-1950 water rights users in Montana. The special master came up with specific figures in response to these questions. I'll turn to those figures in just a moment. Fourth ruling, the special master circled back to the intrastate remedy issue mentioned earlier in relation to the first interim report, concluded that Wyoming failed to provide sufficient evidence that Montana could have remedied the 2004 and 2006 shortages by some sort of interstate means. Said, no, there's not sufficient evidence that Montana could have engaged in self-help, if you will. Lastly, the special master rejected an argument by Wyoming that Montana had to show harm to individual pre-1950 water rights holders rather than just showing that there was a shortage in state line flows during the particular year. Said the showing of statewide flows or statewide flow shortages was sufficient. So taken together, these issues, or these rulings rather, addressed all of the liability issues in the case. And this is how the special master came out at the end of the day. The court should find that Wyoming is liable to Montana in the amount of 1,300 acre-feet for 2004. This represents the impact of Wyoming's post-1950 uses and storage during the 2004 notice period on the flow of the Tongue River at the state line. Further, the court should find that Wyoming is liable to Montana in the amount of 56 acre-feet for 2006. Same text in the latter part of that. Here's the takeaway, though. At the end of the day, what the special master held was that Wyoming indeed had violated the Yellowstone River Compact, had violated Article 5, but had only shorted Montana 1,356 acre-feet under Article 5A. 1 acre-foot is the amount of water necessary to fill an acre of land 1 foot high. It's equivalent to roughly 326,000 gallons of water. It's not a lot of water, shall we say, by interstate standards. Given this figure, the special master suggested that damages owed to Montana very well may be limited to 5 figures and perhaps would fall in the ballpark of only $14,000 after all this. Okay. So in this light, the special master described the remedies phase can and should be short. It's good that someone from the ivory tower can still use their common sense. 1 month ago, today, on March 21st, actually almost a month ago flush, after another round of exceptions filed by the parties and a little over a year of additional time, the 8 justices currently sitting on the U.S. Supreme Court agreed with the special master's second interim report in full. The justices did not issue a roughly 25-page opinion like they had in response to the special master's first interim report. Instead, the justices issued a one-page opinion signed by unanimously all 8 justices taking up the special master's recommendation. The liability phase of the proceeding, in other words, is complete. Again, Wyoming violated Article 5A of the Yellowstone River Compact in 2004 and 2006 to the tune of a shortfall of 1,356 acre-feet of state line flows. And now, in line with the special master's recommendation, the proceeding will move into the remedies phase, which again can and should be short, according to the special master. I spoke with the Wyoming Attorney General's office in preparing for this presentation earlier this week, and what I can tell you is that the states having entered the remedies phase have different views on the proper remedies. Big surprise. Most likely the damages award amount, to be candid. And the special master has required the states to submit a joint list of issues that need to be resolved and a joint schedule for doing so. So up to this point in time, nearly a decade has been invested into this proceeding. Financially, the states have invested $6 million as a ballpark into the lawsuit. $5 million by means of an appropriation from the Montana legislature for outside counsel that they have relied on in the litigation. They have not handled it through their AG's office. They've handled it mostly through outside counsel, $5 million appropriation. Wyoming, $1 million appropriation from the legislature for services from the AG's office. We have handled it in-house. My prognosis is that the remedies phase will be completed around the turn of the year. I think it can and should be short, and therefore that the litigation bill won't increase too much more, but admittedly, that is speculation. Assuming the prediction does come true, however, what do you think? Was Wyoming's $1 million investment worth it from a taxpayer perspective? What about Montana's $5 million investment? Worth it from a taxpayer perspective? These types of normative questions are important. As a UW faculty member, they will consume a decent chunk of my time in coming months. My hope is to complete an article over this summer whose publication essentially can be synced with the U.S. Supreme Court's final decision in the remedies phase of Montana versus Wyoming. The overarching query that has come to me from this material is essentially this. What can be learned from Montana versus Wyoming about the current design of the Yellowstone River Compact and the Yellowstone River Compact Commission, and the use of Supreme Court litigation as a method for resolving compact disputes? We'll see where this question leads, but in the last 3-4 minutes of my presentation, I'll identify 3 topics that have jumped out to me along these lines. An initial topic concerns how interstate water compacts are best handled. I'm admittedly apprehensive that 10 years and $6 million of Supreme Court litigation is the ideal method of resolving Yellowstone River Compact or other interstate water compacts disputes. That is, disputes over how these compacts should be interpreted and administered. What's a better way of going about this? What might be a better way of going about this? How might the compact be improved in this regard? One point of concern brings us back to the Yellowstone River Commission and Article 3F, again pictured here. As mentioned, the Commission is a 3-representative entity, and the federal representative can cast a tiebreaker vote if state representatives disagree on any matter necessary to the proper administration of the compact. Since the 1990s, however, the federal representative has adhered to a policy of abstaining from casting the tiebreaker vote. That paints compact administration into a corner, in my view, and really seems to necessitate litigation. I plan to look further into the subject and related aspects of the topic of dispute resolution. Similar topic involves the current composition of the Yellowstone River Compact Commission. Again, it's a 3-representative entity. Should this continue to be the case? Consider how Wyoming's portion of the basin includes the Wind River Indian Reservation with the Eastern Shoshone and Northern Arapaho tribes, and a host of national forests and BLM lands. Same story in Montana, where we have the Northern Cheyenne Reservation, Crow Reservation, Bighorn National Recreation Area, and a host of national forests. The tribes are sovereign governments under the U.S. Constitution. Why don't they have formal representation on the Commission? Should they? As for the federal government, a few things are worth noting. Number 1, the federal representative is to be appointed at the request of the states. Number 2, the representative lacks voting power except as a tiebreaker. And number 3, the representative's appointment is made by the director of a single federal agency, the U.S. Geological Survey, rather than by the Secretary of the Interior, or for that matter, by the President of the United States. I'm interested in all of these matters of governance related to how the Yellowstone River Compact Commission is composed. One final topic for your consideration. It relates to the compact's apportionment scheme in Article 5. What implications does climate change, specifically climate change's projected impacts on water supplies within the Yellowstone River Basin, have for this interstate allocation scheme? The compact calls for the Yellowstone River Commission to re-examine and potentially modify the scheme over time. And one part of the scheme that is concerning from this revisitation, modification lens is how Article 5A insulates Wyoming's pre-1950 water rights from having to share in potential drought-related flow reductions with Montana's pre-1950 water rights. I don't mean to be unpopular in laying this out in this setting here in Rock Springs, but this allocation of risk fully to Montana's pre-1950 water rights holders arguably seems inequitable, and it certainly seems unsettling. And it's an additional topic that I intend to look into over the summer months. So I'd be happy to talk about all of these subjects and others during the Q&A, and I thank you for your attention.
So we're shorting them 1,250 acre feet,
1356.
1356. So is there an argument over the quantity of water? Does Montana agree with that?
That's whether Montana agrees with it or not. That's what the special master held, and that's what the Supreme Court affirmed. So they may have made arguments during the liability phase up in Billings where they said, no, they actually shorted us more. But at the end of the day, special master had to take those arguments, take Wyoming's arguments, bring them together, and that's the ruling. So that I do not foresee being revisited in any way in the remedies phase. I think that number's set.
So they didn't come to the court with the argument that we've been shorted 15,000 or 150,000 acre feet.
I'd have to look in the pleadings to give you the precise number. I will say the number of years during which Montana alleged it had been shorted in trial, something like over a dozen or 15.
Oh, I see.
And so when the special master said, I'm only going to impose liability on Wyoming for those years in which you provided notice that you'd been shorted, that winnowed that list down to 3. And then further, the special master said, in 1981, I admit you provided notice, but you didn't suffer any injury. So that knocked 1981 out of the box. So out of those dozen or 15 years where shortages originally were alleged at trial, 2004 and 2006 ended up being live ones, if you will, during the liability phase.
Okay, great presentation. I have a definition question.
Oh, here we go.
What is tributary groundwater? I don't understand that term.
It's a term we use in law, probably because of our ignorance of hydrogeology, but forgive us, only so much bandwidth to work with. It refers to water that is surface water and groundwater that is hydrologically connected. Groundwater aquifers that can be shown to influence surface water flows in some manner, as opposed to aquifers that are, again, bad term, but referred to in the law sometimes as percolating groundwater, where you can't show, at least to a sufficient level, hydrological connectedness between the aquifer and the surface water system.
And that was the crux of the issue in the North Platte decision.
Oh, in North Platte litigation. Yeah, I'll say one thing on that, and welcome questions from others as well. The design of interstate water compacts over the course of the 20th century was completely about surface water flows. Our understanding of hydrogeology and the interconnectedness of surface water and groundwater was not what it is today. And so the hard part is you have these interstate allocation schemes that pertain to surface water, but we now know the surface water, from a scientific perspective, is connected to the groundwater. What do? Do you go back to the compact and amend it, right? Or do you take the existing compact text and interpret it in a way to say, well, this wiggle word here seems like it suggests groundwater can be encompassed within the allocation scheme. These are real issues. The treatment of groundwater under interstate water compacts will be a significant issue for the next 10, 20, 30 years.
Okay, one closing question.
Yes.
Then I'll shut up. Has there ever been an interstate water compact that covered more than one drainage?
More than one basin?
More than one
Or watershed? This is a major topic of my research. The compacts I know of in the West do not. The lone caveat I will give is this. Some compacts, the Colorado River Compact for that matter, will define a basin for legal purposes as encompassing the hydrological basin itself, as well as all areas to which basin water is exported. So under the Colorado River Compact, Los Angeles and San Diego are part of the Colorado River Basin. Denver and the Front Range are, as a matter of law, part of the Colorado River Basin, based upon how that term is defined in the Colorado River Compact. So you do have that, but I don't know if they've tried to fold in more than one full catchment, not to my knowledge. Other questions? I love this stuff, so it's my pleasure to answer questions, truly. Please.
So in Wyoming's Constitution, Article 8 talks about how the water is property to the state. And I was just wondering if this had any big major effect within our Constitution according to these water compacts, particularly this one.
Sure. So the design of Article 8, Wyoming's constitutional provisions bearing on water resources, and Title 41 of the Wyoming statutes, very sophisticated. We were fortunate. We had a gentleman by the name of Elwood Mead come to the Constitutional Convention in 1889 and helped design Article 8 and set up Wyoming's water administration system. Meade was a spectacular figure for reasons I won't get into. But the notion that water is property of the state in no way kind of derogates from this idea that Wyoming can form water compacts with its neighbors that define Wyoming's share of water from an interstate river and the neighboring state's share of water from that interstate river. Not at all. You can have Article 8 apply within the four corners of the state of Wyoming, right? And management can occur to water or for water to which Wyoming is entitled under an interstate water compact, but at the same time, Wyoming would have to satisfy any compact obligations it had assumed purely as a matter of federal law. So there's no dissonance there.
With climate change and global warming, more and more incidents of drought every place, plus the science has given a much different perspective of what's going on with water than back in 1800 or early 1900. Is there any movement to really significantly change the laws to match with what's happening today?
Right. It's fascinating. I've come to think of the compacts as legal infrastructure, the same way that an engineer might think of dams and reservoirs as physical infrastructure. And the notion that you can cast into concrete for all time an interstate water allocation scheme, regardless of changes in contemporary values, regardless of changes in climatic conditions, just seems as foolhardy to me as a notion of an engineer being able to design a dam that is going to survive the test of time, Hoover, Glen Canyon, or otherwise. But that said, if you're asking my view on that issue or kind of my observations, anytime I've broached that subject of the revisitation of existing compacts, their potential renegotiation, most serious, or their potential amendment in more of a laser-like way, amending a specific provision but not taking the whole thing out. Anytime I've broached that subject in public settings with public officials, it has not been received favorably at all. And I don't know if that's a public face dynamic, to be candid, but truthfully, they uniformly have said, no, we're not going to revisit these compacts and so forth. So
many things have changed. I mean, back then, water was primarily an agricultural use. Now it's being used for a lot of industrial use.
Right. Craig asked me to do this. So I mentioned last night when we were at the reception trying to give a trailer to my talk, touch water in the West and you touch everything, right? Touch water, that's Wayne Aspinall said that, Colorado representative, Western Slope, Grand Junction. And it's true, and as that bears on your comment, there's not an aspect of the Western states economy that isn't somehow implicated by water. I don't care if it's ag or energy, recreation and tourism, or whatnot. Similarly, political relations are inherently mobilized and sometimes polarized as a result of water. Social relations, Indian, non-Indian relations particularly, are definitely implicated by water resources and relationships over water resources. So yes, when it comes to making rules for how water should be allocated and how water allocation arrangements should be governed or crafted, those rules exist in a social context where you have constantly changing economic conditions, social conditions, values, as well as on the ground, climatic and hydrological conditions. It is a very, very dynamic situation. But all that said, I go back to my remark a moment ago. I have not heard any public official in the Rocky Mountain region come out and suggest any existing interstate water compact should be renegotiated or amended. That's my experience. Ask others. Dave.
Oh, thank you, Professor Robison. I understand that the state of Colorado has made residential rain barrels illegal, and then I heard recently that law has possibly changed, or at least I saw a headline the other day that made it sound like that. Is this happening in other states? Because I just learned about this recently. We're getting some landscaping done at our house, and trying to be environmentally conscious.
Free legal advice.
But our landscapers, a little bit of advice here as well. Before I invest in these rain barrels, she said, well, good news, you don't live in Colorado, so it's legal to do that here. And I said, what? It's illegal in other places to do that? Understanding that even rainwater is considered property of the state.
Yes.
Is this playing out across the nation?
So I would say this, whereas my talk here today is focused more on interstate relations, intersovereign relations to the extent that the tribes been integrated into my remarks. Dave's question relates to the interstate rules. Wyoming water law would govern rain barrel harvesting, just like Colorado water law. This issue of capturing water in rain barrels, yes, it's definitely been a live one in the Western state legislatures over the past 10, maybe 15 years. I believe I'm not as knowledgeable about, number one, Colorado water law and a lot of the intrastate rules. To try to keep tabs on the 17 Western states, changing codes and changing judicial decisions that involve a change to it's a tall order, right? But I can say, yes, it's been a hot issue. I think Colorado is in the minority. I think that most states like Oregon have been more progressive because of their policy stance on the value of rain barrel harvesting. But you're right, Colorado, up to this point in time, is not allowed it. So. Please.
You had the open-ended question, is it worth the money?
Yes, what do you think?
And my thoughts are yes, because you're speaking to it today. We live in the upper reaches of the Colorado Basin. She lives within a mile of the Savory Creek and where the compact starts. We had leaders in our community that were involved in that. And I think it's a powder cake, the Colorado River Compact and, and all. So dollar-wise, certainly for Wyoming, defending, I think, in my opinion, yes.
So
maybe for the acres of water that was gained, not so much, but for the big picture. And it brought you here today.
Well, I'm grateful.
We're talking about it.
How about this? Let me play devil's advocate, because that's what law professors do. A little bit Socratic method. So another very expensive proceeding that the Wyoming taxpayers have been saddled with in recent years, going back several decades, was the Bighorn General Stream Adjudication. Right? It was filed in 1977 up in Worland, and it took 37 years for the final decree to be signed by the trial court there. There were a couple subsequent appeals, not a major deal, but the Wyoming Supreme Court disposed of those during the following year. So 37 or 38-year complex civil proceeding involving the tribes, the feds, the state, right? I don't have accurate price figures for you on that. I've interviewed people asking if there had been a budget kept for the ultimate expenses in the adjudication. But I can tell you, probably the most knowledgeable person I know in this regard is former Judge Gary Hartman. I think he's with the governor's office the last time I checked. He placed the price tag of the Bighorn adjudication at maybe $100 million. $100 million worth it? Who gets rich? My students? Not me. But I think it's an important question. If we care about fiscal responsibility, and I think everybody should, right? Is litigation the best way to put our money toward ironing out our fights with our neighbors? Could that money be put toward other things if we could find a dispute resolution method involving negotiation or compromise as opposed to some dualistic adversarial dispute resolution process? I think these are important questions that we need to ask in the water realm and more broadly, if we care about taxpayer money. So that's my opinion.
Well, I think you're right. If there's a better, is there a better method?
Yeah.
But was it worth it? Yes.
In this case, $1 million by Wyoming for 10 years. Yeah, $5 million for Montana. For me, that pushes it a bit more. If it were double digits, 10, 20 million, I might start slipping, the other way.
In your examination of the years that it took to deal with this, we saw these decisions, I think, originally based upon agricultural use, ranching and agriculture. Did you see the influence, and I'll use the word influence, of political figures and moneyed interests in, and I'll say influencing, not buying the decisions that were being made, especially, say, development of population centers with their infrastructures?
I think I would be fronting if I tried to kind of diagnose all of the political influences that have been exercised on the initiation of litigation and the development of it. I don't have that. I'm not an insider. I'm on the outside as an academic, so I don't have that insider's perspective. At the same time, I do wonder why, again, from the outset, why did they have to engage in Supreme Court litigation for this compact disagreement back in 2006? Which powerful stakeholders and which decision makers over in Cheyenne were most keen on engaging in Supreme Court litigation? And I guess to be fair, because Montana filed the complaint, maybe it has more to do with powerful influences and decision makers in Helena as opposed to Cheyenne. Maybe we're more on the receiving end, to be fair, but I have no delusions that those forces exist and have exercised influence on the litigation. Precisely who they've been, I haven't lived with the material long enough to give a solid answer.
I'd like to thank Professor Robison. Excellent presentation.
Thank you very much.